Welcome everyone to our webinar on business divorces, exiting directors and shareholders from your company. My name is Paula Kumar and I'm a practice leader in LegalVision's disputes team. I'm joined today by my colleague Sarah Aldersley, who is a practice leader in the corporate team. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email. Submit your questions in the QA chat box and we'll answer them at the end. And please complete the feedback survey after the webinar. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today we'll be discussing common causes of director and shareholder disputes, how to avoid such disputes, the first steps for dealing with a rogue director, legal options for removing a director, legal options for shareholder disputes, and lastly, the Q&A session. So just to start off, by looking at what the common causes of director and shareholder disputes are. So number one, typical kind of inquiry that comes over is that there's a disagreement over the direction of the business, performance or day-to-day management of the business. You start a company with a trusted friend or family member, obviously with the best of intentions to create a successful company, but somewhere along the way you have disagreements about how the company should be headed or how the company is performing. And those disputes could also be over finances and the spending of company money. Could also be a breach of fiduciary duties. There are 7 fiduciary duties that a director owes to a company. Very briefly, those are duty to act within powers, duty to promote the success of the company for the benefit of members as a whole, duty to exercise independent judgment, duty to exercise reasonable care, skill and diligence, duty to avoid conflict of interest, duty not to accept benefits from third parties, and a duty to declare interest in proposed transaction or arrangements. Most common breaches are a director who's poorly performing their duties, so they haven't been devoting sufficient time and effort to the obligations that they owe, or perhaps they approve a risky venture without adequately considering the risks and impact that it would have on the company. They might be failing to properly monitor compliance in the company's operations. Or it could be a conflict of interest. So they have an interest, perhaps in a competing company, fail to declare that interest and drive business away from the company. Another typical dispute is a shareholder deadlock. So again, very, very common for companies to start off with 2 directors and 2 shareholders on a 50-50 basis. And quite often when you start a company with those best intentions, you're not thinking about what might happen and at the end and how the relationship might deteriorate. And so you don't have a shareholders agreement in place and you only have model articles for the company. If you do have a shareholders agreement, there could be a breach of their shareholders agreement or even the articles of association. And it could be something such as the procedure for decision making, such as where decision is made by the company without the required majority of shareholders, or perhaps shares are not sold or transferred in a way which breaches the procedure that's set out in the shareholders agreement. Quite often there will be very strict obligations for confidentiality and also some restrictive covenants, and those might perhaps be breached as well.
Yeah, so because of these risks, we recommend from the outset having proper corporate governance documents in place. So these will help to avoid disputes because you can be clear on what each person's obligations are from the outset, but also they will set out what happens in the event that there may be a dispute. So the main document are your articles of association. So these are effectively the rule book for how the company is run. When you set up a company, by default, you will be given what's called the model articles. So these are a basic set of rules that apply if you haven't adopted anything bespoke. They do contain one provision which can be helpful in these situations. So they give the chairman of the board a casting vote in the event that there's an equal number of votes for and against a decision. So if you do have an even number of directors on your board, this can be useful to sway the decision one way or the other, but only really if it's clear who your chairman is in the first place. However, the model articles don't contain any provisions regarding buying out shareholders in the event of any dispute or any issue. So because of that, we recommend putting in place bespoke articles and a shareholders agreement containing specific provisions which deal with any director or shareholder issues. So this could be a clause, for example, around deadlock resolution. So if the directors aren't seeing eye to eye on a particular decision, either setting out that one of them will have a casting vote and specifying who that person is. You could perhaps say that in the event of a deadlock at board level, the decision can be escalated to shareholders. That will only help if you have shareholders that aren't holding shares in equal numbers and are the same as the directors, obviously. But if, for example, you had 2 directors and 3 shareholders, and that third shareholder could help to decide the matter. Or failing that, in kind of a Armageddon situation, you can have clauses which set out what happens if you really can't reach an agreement, and often that tends to be a buyout by one party of the other's shares. And there are also other provisions you can put in your articles and shareholders agreement to do with compulsory transfers. So these will be particular situations that occur, which then allow the board to require a shareholder to sell their shares. So that tends to be things like the shareholders breach the articles. So in the example Paula gave, if they transferred their shares without going through the proper process, that could be a breach of the articles. The directors could then require that shareholder to give their shares up. And also things like insolvency of a shareholder. And one of the main ones which you may have come across before is something called the leaver provisions. So these apply where if you have a director who's also a shareholder, so they're working for the business, if they stop working for the business or there are grounds for the company to terminate them, then the leaver provisions can kick in and they set out what happens to their shares. So there's 2 main categories here. So one is bad leaver, one is good leaver. So as the name suggests, a bad leaver is someone who leaves the business under specific circumstances of sort of wrongdoing. So they might have breached a non-compete obligation, or they might have been dismissed for gross misconduct. So normally in these circumstances, the other directors can decide that that person is forced to transfer all of their shares. And that can be to the other shareholders or back to the company. And you set the price at which this transfer happens. So normally with bad leavers, they just get back nominal value or the price they paid. And normally because they're sort of founder shares or kind of employee shares, the price paid tends to not be very much. So it's quite a high penalty. And then conversely, you have good leavers, often drafted quite broadly. So it encompasses anyone who isn't a bad leaver. And you have a decision as to what you put in your documentation. So you can say if someone's a good leaver, they're fine, they can keep their shares. Or you can say, even though they're a good leaver, they still have to sell their shares, but for market value. So there's not kind of the same penalty that you have with a bad leaver. You can also tie vesting in with this. So you can say someone's a good leaver, but because they left within a certain number of years, actually only some of their shares qualify for the full market value, and the rest actually do get transferred at nominal value because they haven't sort of been deemed to be earned them yet. So as you can see, these leaver provisions can be really, really key in this sort of circumstance. So, you know, if a director is terminated, but they also hold shares, those leaver provisions give you a chance to take the shares from them. But it's important to take a step back and think, when can a director be a leaver? So this is where it's very important to have in place proper contract between the director and the company. So often it's a director's service agreement, could be a contractor agreement or a non-executive director letter, something like that. But that will then set out what their obligations to the company are. So how many hours they've agreed to work, what their roles are, what their responsibilities are. Then it can be quite clear if they've breached that, and then you can put in place proper performance management or activate any termination clauses under that contract to then get rid of the director, which would then trigger the leaver provisions kicking in.
So rogue directors can be extremely harmful to the business and cause significant disruption. In some situations, the company's business may come to a complete standstill if decisions can't actually be made. So the key thing is really to seek legal advice as early as possible. Disputes with directors are technically complex and the issues involved are often substantive. And a specialist dispute solicitor will be able to assist you with forming a strategy and negotiating an exit, ideally without having to issue proceedings. The first thing is to try and resolve the matter. Often open and informal discussions can resolve a matter amicably before they become too heated. If that doesn't work out, then there may be a statutory procedure for removing a director, which you can take advantage of, which Sarah will talk about soon, or there is the litigation route. So the first step there is to prepare a letter before action, and if that in that letter, it's a formal letter which sets out the basis for the claim and what the next steps are for the matter. It might include a claim for damages, so you would be seeking some sort of compensation for perhaps the breaches of duties that have occurred. You might be trying to seek injunctive relief. So you might say that the next step would be to apply for an injunction to stop them from continuing the harmful breach. If, for example, they've been misappropriating assets. Another potential option is the disqualification route. There are a few ways in which this could happen. Potentially disqualification, it could be up to 15 years, and that would mean that the director is not able to act as a director for any company at all. In most cases, this is initiated by the Insolvency Service, which has the power to investigate the conduct of directors of insolvent companies. For example, where the director is unfit, they've been failing to submit accounts or drawing excessive salaries, knowing that the company is insolvent. You can potentially also petition the court if there's been some serious misconduct, for example, wrongful or fraudulent trading. Another thing to consider if you are in a regulated sector is whether you need to report the director to your regulator, which potentially would then result in them investigating the conduct, and there may be some enforcement action that is taken after that.
Yeah, thanks, Paula. So one of the things Paula just mentioned was a statutory regime for removing a director. So this is a right under the Companies Act, which allows the majority shareholders to remove a director. So it can be one shareholder who holds more than 50% of the shares, or it can be multiple shareholders acting together who own more than 50%. And that's the shares with voting rights that are important there. If you have a 50-50 board, so one director is kind of the rogue director and the other director wants to pass that shareholder resolution, then you will be stuck at board level not being able to call that shareholder meeting, because presumably the director that's being potentially voted off won't want to call that meeting. So what you need to rely on there is a separate statutory process where the shareholders who hold 5% of the shares are allowed to require the board to call a shareholder meeting. And again, that can be one shareholder with 5% or a handful of shareholders that together have 5% that can instigate that process. So it's quite a formal process to requisition a meeting, and there are some strict rules on timing that needs to be complied with. So recommend engaging a lawyer to assist with this. Once the process has been followed, so the shareholders requisition the board to call the shareholder meeting, the board does that, the shareholder meeting goes ahead. If at that meeting, the majority shareholders do decide to remove that director, then the director actually has no recourse against the shareholders for this, even if they had no particular reason for the removal. The only time they would have recourse is if you've separately contracted with them that they are allowed to be a director on the board for a certain amount of time. So, for example, you often see, founders having an entrenched right to be a director for so long as they hold any shares. So if a company went through this process, the shareholders agreed to remove that director. There's nothing they can do under the Companies Act, but they could potentially have a claim under your articles or shareholders agreement, for example, saying, I still hold shares, therefore I should still be on the board. You also have to consider any employment rights, because if that director is also an employee, if you take them off the board and terminate their employment at the same time, that can obviously amount to an unfair dismissal potentially, or discrimination claim. So just being aware of other claims that director might have outside of the Companies Act. So obviously in a company where you actually have the same shareholders as directors and you've got that 50-50 split, so you've got a deadlock, the shareholder won't be able to rely on this statutory right because they themselves don't hold more than 50%. So unfortunately, in that circumstance, this right doesn't actually have any teeth. So instead, what we'd be looking at is, are there any provisions in the company's articles or their shareholders agreement which set out how a director can be removed, so we can rely on that process instead of the statutory one? If there isn't anything in there and they can't rely on the statutory process, then it will be a case of just negotiating with the director and getting them to resign as part of your settlement discussions. So there's also then the consideration of, what if that person has shares? So we've sort of gone through how you can remove them as a director, but then how do you deal with their shareholding as well? So if you have model articles and no shareholders agreement in place, then, which is normally the default position if you're a startup, there's nothing in those documents which allow either the company or the other shareholders to take shares from that person. So you would have to actually agree the transfer of their shares and the price at which they're selling as part of your settlement discussions. So you can see why it's really key to have in place bespoke articles and a shareholders agreement to mitigate against this risk with someone still holding a large proportion of the company, even though they're not involved anymore. So this links back to what I spoke about before with the compulsory transfer provisions and any leaver provisions. So if you did have a situation where a director is removed, ideally that then triggers the leaver provision, so then you can also deal with their shares. It's also a good idea to have a power of attorney clause in your shareholders agreement. So in the event the director isn't playing ball, you've followed the leaver provisions, you have a legal right to take their shares from them, but they're, say, refusing to sign the share transfer form, the directors then can act under a power of attorney to do that for them. So that's another really, really useful thing that you can have.
So assuming that your corporate governance documents don't help you out in this scenario, the directors could issue shares to another shareholder or an investor to try to dilute the offending shareholder shares, but you need to be aware of potential unfair prejudice claims and, of course, needing to act in accordance with directors' duties. There could be a provision within the shareholders agreement or articles requiring the parties to participate in a mediation before a claim can be issued. And this is where you have someone that is a completely independent third party who tries to facilitate a settlement between the parties. If there is no provision within a shareholders agreement or articles, or you don't have them, then parties can still agree to a mediation. So it can be a very helpful tool to have. Litigation is a last resort and could potentially result in a winding up of the company. So really the last thing that you sort of want to be thinking about. There are various ways to wind up a company, and which option is most appropriate will depend on whether the company is solvent and the circumstances in which it is being dissolved. If it is solvent and the majority of directors are in agreement, you can apply to have the company dissolved. The main issue with this is that creditors or interested parties can raise an objection to this, which is going to freeze it and may derail the whole process. If a shareholder or director believes that the company is not being managed properly or there is a 50-50 deadlock, then you can apply to the court for the company to be wound up on just and equitable grounds. If a director wants to present the petition, they must either be the sole shareholder, an original shareholder, or a registered shareholder for a minimum of 6 months in the 18 months prior to the petition being presented. The company is effectively liquidated and the shareholders split the assets. You must be able to demonstrate that a tangible benefit will be derived from the winding up of the company. So it's got to be solvent. And the court has very wide discretion in making an order on this basis. Otherwise, if the company is solvent and there is a majority shareholder holding at least 75% of the voting shares, or a handful of shareholders who together hold 75% and they're in agreement, the shareholders can pass a resolution for a member's voluntary liquidation. This can be an attractive route as it can't be objected to by creditors and it doesn't involve the court, but it is more costly than a simple dissolution, as a liquidator will need to be appointed to distribute the assets to pay off the creditors and then the shareholders.
Great, thanks, Paula. So that concludes the main part of our webinar. If you do have any questions, be putting them in the chat box now and we can get to them. Wanted to flag that we've recently published a guide on directors' duties in the UK. You might find that really useful if you're dealing with a road director, so feel free to download it from our website, or there's a link to a QR code in the slides that you'll be sent after today. We also have an upcoming event that might be of interest to you. It's on the 13th of August at 11 AM, and it's on 5 legal essentials that startup founders need to know. So very general and very relevant to anyone who's starting a business. So while you're submitting your questions, I'll just briefly talk you through our LegalVision membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. So it's effectively like having your own in-house counsel, but for a fraction of the cost. We can assist you with things like unlimited document drafting and reviews, unlimited legal advice consultations, and unlimited domestic trademark registrations, as well as much more. So as a member, you won't need to worry about the cost of lawyers ever again, because we take care of all the business as usual legal work for a fixed cost, so you can just focus on running your business. So if you do want to learn more about how the membership could help you, you can request a free consultation with us when the survey appears at the end of the webinar. So now we'll get to the questions. So there were a few that were submitted before this webinar. So I think we'll go to those first, and then we'll move on to any that get submitted in the chat box. So the first one that was submitted was how to deal with financial incompetence and failure of fiduciary duty due to mental health conditions, which the co-director does not accept. So in this circumstance, firstly, you would need to look at, has there actually been a breach by the director? So that could either be of a fiduciary duty that they owe that Paula set them out earlier, there's 7 of them, or a breach of any agreement the director has with the company. So if you're looking in terms of fiduciary duties in this situation, the question said, financial incompetence and general failure. So probably one that's going to be relevant here is the need for directors to have a duty to perform their role with reasonable care, skill, and diligence. So how you measure if a director has done that is based on what a reasonably diligent person would do as a director of that particular company, but also taking into account any particular skills that director has. So, if you're a very small company, very much startup territory, what's expected of a director in that circumstance isn't going to be the same as a director of, say, Amazon. It's going to be totally different. But you do look at any particular skills that director has. So if we're talking about financial incompetence, I'd be thinking, does this person, do they have any accounting qualifications? Are they an accountant? If so, I'll be holding them to a higher standard than just your reasonable director of a small company and what they should know about the finances. So let's assume there is a breach. You would then be looking at, okay, what remedies are available? So that will depend on what kind of breach is. It's not really clear from the question here, but you would look at any services agreement that they have with the company. Does what they've done give you grounds for termination? Otherwise, if we're looking at the statutory duties, can you bring a claim on behalf of the company for breach of a duty? And Paula sort of went into some remedies before. So is there a compensation you're seeking, or you could ask for an injunction? It's worth noting as well, these particular circumstances, it sounds like there's also some mental health issues at play. If the company has model articles, then there is actually a provision in there that says a person will cease to be a director if a medical practitioner who's treating that director gives evidence the director is physically or mentally unable to perform their duties for a period of at least 3 months. So there's often something along those lines in sort of bespoke articles as well. But I mean, the key thing here is you do need to have it kind of signed off by a medical practitioner. So it's not really good enough for the other co-founder just to say, I think this person's having health issues and they can't fulfill their duties. If you're relying on this particular right to immediately terminate them, there would need to be some medical evidence. But hopefully that helps. So looking at the different steps that you would go through. I will also take the next question and then hand back to Paula. So someone has asked, if a leaving shareholder or director wants to take the property that he bought to the company when he entered, is this achievable? So I will assume the director's leaving in amicable circumstances here and has just asked for the property back that they first gave to the company. So whether you can hand this back really is going to depend on what that property is. For example, if it's something like an IP asset, for example, if it's been fully integrated into the business, it might not actually be practicable for you to give it back. And equally, if it's a really important asset, you need to make sure your company can still run going forward. So you might not actually be able to give it back to them without sort of completely messing up your business. But if you can give it back, then really it just falls down to a commercial decision of A, do you want to, and B, kind of what are the terms around that. I would be looking at when that property was first given to the company, is there kind of a corresponding entry in your accounts for a director's loan amount? So was it actually the case that this property was lent to the company, in which case it's not the company's property, it still is the director's, it's just on loan. So you would at some point have an obligation to give it back. And I'll be looking at what terms on which that loan was made. But if not, if that property was given to the company and the director got shares at that point, for example, then that is an investment, that is company property now. So you would have to agree the terms on which you're giving it back. It is possible to give it back, assuming that what I said before about it being integral or integrated doesn't apply. But what I would recommend is that you take tax advice as to the consequence of that, because if this person is a shareholder, it could be deemed to be a distribution of assets to them akin to a dividend. So there can be some income tax payable. Equally, if they're a director, there could also be some tax consequences of doing that. So yes, it is legally possible depending on what you've commercially agreed, but definitely good to take some tax advice.
Another question that's come up is, if the shareholders agreement is governed by English law, but the company is based in an overseas territory, how does this affect dispute resolution, and what specific considerations should we be aware of? So that's a really good question. You see there's quite a lot happening. So where a shareholders agreement is governed by English law, just generally because it's a better known and more neutral territory. Firstly, we'd be looking at the dispute resolution clause in the shareholders agreement, as this may set out what process needs to be taken if there is a dispute which falls within on the terms of a breach of the agreement. So, for example, there might be an arbitration clause in there, and typically agreements with overseas entities will favour arbitration over mediation. The arbitration clause may set out that the seat is England, and that's effectively just saying that it's the jurisdiction to which the arbitration is tied and what the legal framework is. So it's really the first thing to look at is whether there is such a clause in the agreement, and how the process of dealing with the dispute. Even if there isn't a dispute resolution mechanism, there may be a clause in there which says that in the event of a dispute, the English courts have jurisdiction. But again, you need to look at whether this is this jurisdiction is exclusive, or it could be non-exclusive, which would give more flexibility for the parties to choose which court is competent to hear the dispute. But if it's an exclusive jurisdiction, then it would fall within the English courts. The next question was, when shareholders are also directors, how does this dual role impact dispute resolution? And are there any specific legal considerations or conflicts of interest under English law for an overseas entity? We've touched on this a little bit already, but effectively directors and shareholders have different roles. It's directors that owe fiduciary duties to the company, and they may also have other obligations under their service agreements. One of those duties is to avoid conflicts of interest, which is really there to prevent fiduciaries from being swayed by divided loyalties or self-interest. Shareholders typically don't have any liability to a company other than to pay for their shares. So in a disputes context, usually you would bring a claim against a director and then also try to take their shares from them, either under the terms of the articles or shareholders agreement, if there are leaver provisions like we mentioned earlier, or perhaps under as part of the settlement negotiations.
Yeah, there's another question, which is how to avoid minority discount on a sale of shares for a minority 40% shareholder and reasonable timescales for buyout. So this isn't necessarily going to be linked to a director dispute, for example, but I can see how that could happen in a situation where you have a director who holds shares and then you're trying to agree a price for those shares. So it really will depend on the context. You know, if you had a minority shareholder that's just negotiating a sale of their shares with a third party buyer, then it's up to them to try and get the best price for those shares. Often you do have to offer those shares at that price to the other shareholders first before you can actually sell to a third party. So that's worth flagging, but you know, that would sort of be a normal context of just a typical sale. So if it's actually the context where that minority shareholder is being bought out either by the company or by other shareholders in the event that they've left or there's been a breach, then you'd look at, is this buyout happening under the terms of any legal provisions in their articles or their shareholders agreement? Because typically, if that's the case, there will often be a mechanism for what the value of those shares should be. So normally, as I said before, there's going to be a distinction between bad leaver and good leaver. For bad leaver, normally you don't need to worry about valuation because it's very clear they just get nominal value or their price paid. If it's a good leaver situation, or you've perhaps got a price that's payable that's a discount to market value, you would need to work out what the market value is. But normally in these provisions, they also set out a mechanism for how that's determined. So typically what you'll see is it will be the price that's agreed between the board and the selling shareholder. But if they can't agree a price within a certain time frame, then that would go to an independent valuer. And typically there are then assumptions that need to apply when that valuer is deciding the value of the business. So things like there's a willing buyer and a willing seller, but also sometimes it says, you know, assuming that there's no discount for minority shareholding. So that's where I'd be looking to see if it has anything in there about the fact that it's minority shares. If it does, and it's, you know, being drafted in the normal way, I would expect it probably says don't discount for minority. So effectively you would just value the business and divide that valuation by the issued share capital to get the share price. You know, the majority shareholders don't have a greater share price than the minority. Everyone just would have the same share price. Obviously, if there are no provisions in your documents, then you can't rely on them. So I would expect in that circumstance, the person is selling their shares as part of a settlement discussion. You know, they've commercially agreed to do that. So it'll just be a case of, again, just agreeing the price with them. There's not going to be anything that will help you to determine how that's agreed if there's nothing in your documents. So it'll just be a commercial conversation. And there was also part of that question around time scale. So again, this will depend really on how this share transfer is happening. So if it's under the leave provisions in your documentation, then there'll probably be a set process. So for example, they have a certain amount of time to agree the price themselves. They can't, there's a certain amount of time to appoint the valuer, valuer has a certain amount of time to come up with the valuation. So you can see that the timescale can start escalating quite quickly. So it can be sort of, you know, a month to a few months, if, you know, you do have to go through all the process step by step. If you have a situation where, you know, the person leaves, you agree the price pretty quickly, maybe don't have any preemption provisions, or they've been waived by shareholders. So by that, I mean, you don't have to first offer those shares to shareholders. You can just sell to the person that you've identified to buy those shares, and you could do that pretty quickly. But yeah, typically it's going to be a case of going through a set process. So it might take a little bit of time. Great. So no one has asked any questions while we've been talking, and they were all the pre-submitted questions. So I think unless someone has a burning question that they manage to type in the next few seconds, we'll leave it there today. So don't forget, a survey will pop up at the end of the webinar. So we'd really appreciate it if you could complete it. It should only take about 30 seconds. And if you want to receive your complimentary legal consultation, then make sure you pop in your contact details in the survey so we can then get in touch with you to discuss how we can help. So thanks very much for joining us.